Former President Jacob Zuma wants the High Court in Pretoria to review and set aside the appointment of Judge Raymond Zondo as Chief Justice. In a letter addressed to President Cyril Ramaphosa in May this year, Zuma's legal team raised concern about how Zondo was appointed as Chief Justice of the Constitutional Court. The former president is accusing Zondo of being dishonest about meetings he held privately with Jacob Zuma. Legal expert Elton Hart joins us now for this discussion. Elton, thank you very much for your time this afternoon. So the former president made this intention known in May already, and the president, the current sitting president, Cyril Ramaphosa, made known his intention in September to oppose the application by the former president. The time lapse from May to September, is that unusual?
I don't think it would be unusual. One has to first look at, was if I write you a letter, and which is a letter of demand to say, listen, yeah, you've done me wrong and I want you to fix it, doesn't say that I've issued court papers. So one needs to look at, when did the former President Zuma actually approach the court, when it means that he approached court to actually get an application to review the decision issued by court, given a case number, and then serve it on the current president, who is President Ramaphosa. So in terms of our rules of court, the uniform rules of court, then you have 10 days in which you have to actually respond after the sheriff has duly served you with the initial application. So one needs to just get that clarity pertaining to when did they issue that application. If we know that date, then you know, was he in or out of time. But obviously, before a judgment has been given in any matter, a person can file a notice of intention to oppose or defend a matter before judgment has been given. If that judgment has already been given, then there's a different process. But it allows the president, the current President Ramaphosa, at any stage to say, I want to oppose this application. Obviously, there might be punitive costs for him failing to file timeously, but we cannot say that he failed to do so at this point in time, because we don't know when that papers was issued and actually duly served by the sheriff of the court on him. So if we have that dates, then we can narrow it down to say he's in time or out of time.
Sure, because according to the statement issued, the Jacob Zuma Foundation statement issued on the 3rd of October, it reads, His Excellency President Jacob Zuma and the JG Zuma Foundation previously launched an application against the President of the Republic in the North Gauteng High Court seeking relief to declare the conduct of the President in appointing Judge Raymond Zondo as the Chief Justice of South Africa to be unconstitutional and to review and set aside the decision to appoint him. It then goes on to read, accordingly, the next step in the process will be the compulsory provision by the JSC and Mr. Ramaphosa of the record of the proceedings and deliberations pertaining to the JSC's recommendations and the President's decision. Is that obvious? Is that obviously the next step of what's going to happen legally?
No. If he brings that application, obviously what the president, if he filed his notice to oppose, the current President Ramaphosa, he filed his notice to oppose, and obviously the application that was served on him, which is a notice of motion with a founding affidavit, it will set out certain round of events. Then he has to answer what we call an answering affidavit, giving his answers pertaining to certain provisions in that founding affidavit. So once that pleading stage, if one can call it that way, because it's not really pleadings, but it's exchange of affidavits between parties, if that time period is penned out, then the matter will be set down for hearing. That's only when you will now get to the meat of it and the gist to say. But if one looks at what the Constitution requires of the President, is to say, in terms of Section 174, the President appoints the Chief Justice in consultation with the JSC and the leaders of political parties. So if the President can prove he has done his consultation, he consulted with them, it still gives the president more power to say, although I've had this discussion, I still have my own mind to apply to it and then decide who I'm going to appoint. So it's not if the JSC makes a recommendation that the president must rubber stamp that decision. He can still apply his mind in who he appoints, especially when you get to the heads of these courts, like the Constitutional Court, the Supreme Court of Appeal. You can give him a couple of nominees and he can then apply his mind from that nominees who he wants to appoint. So that is normally how the process works. It's a little bit different from when you have the normal judges being appointed.
In applying his mind, according to the statement by the Jacob Zuma Foundation, he is being called upon to dispel the allegations or suspicions that Zondo was being unduly rewarded for absolving Ramaphosa for his role in the Bosasa CR17 scandal, among other things, in the so-called State Capture Commission report. They further say he must explain why he overlooked a woman candidate when she had, in any event, received the highest votes. Such conduct is in breach of the Equality Clause, Section 9 of the Constitution, and Section 1742 of the Constitution, both of which prohibit gender discrimination. Is there a case to be made there?
If we talk about the gender discrimination, because I know the new guidelines say specifically, and it's constitutionally required that there is gender equality and race equality within the appointment of the judiciary. And if one can say that Judge Maya, which was the candidate that was also considered for the Constitutional Court top job, and she scored highest on what the JSC has come up with, then the president must come show on reasonable grounds why he would have deviated from appointing Judge Maya if she was scoring the best, and also to make sure that race, gender is properly represented in the top court of the country. So that guidelines that was there, and I think it was adopted around October 2022 or a little bit earlier, but I know the new guidelines is there. So then the president needs to come and explain. I think on that front, there should be some explaining to do why the president opted to even go for Judge Raymond Zondo at this point in time, knowing that 18 to 24 months he would be sitting in that court, and then we have to go again for new interviews to actually get a Chief Justice appointed. And I know the argument that was put out already is to say that, listen, we want to just give Judge Maya the time to also ease into the process. He still has experience to bring. So that rationality must be explained to a court, and then the court will decide, is it correct? Also, but also, if one looks at it, you don't necessarily want the top court job to be contested and contested very vigorously, because it might show that there's maybe like a sort of factions within the judiciary, and we as the judiciary, or the judiciary, should be seen as one. So I think there is explaining that the president needs to come and do, but I've also heard some reports already in the media that they try and explain it. But obviously, if Judge Maya scored higher, the political leader said this, then the president needs to come and give good reason as to why. The assertion that he was rewarded for exonerating the president in the Bosasa scandal or matter, I think they need to really bring hardcore evidence to the fore to court to say why are they making that assertion in their papers that they issued. Yes or no, we don't know why they're doing this, but they need to come and explain clearly as to how they draw the link, and why would they say that the president, as he was then, when the former president was still the president of this country, how they link him to the Bosasa and the dealings in the Bosasa, and how Judge Raymond Zondo's action exonerated him. And then one is to go look at the Commission of Inquiry, which is the State Capture Commission. Who framed the terms of reference for the commission, and was it framed? Then they must come and say it was framed so favorably that it favored our current president, and it was against the former president in this instance. But there's still a lot of water that needs to flow into the river. Obviously, when they give the answering affidavit, the former president then has a chance to actually file a replying affidavit to the answers that was given by the current president in his answering affidavit.
What are the chances? Because the president has filed his notice to oppose the application, while the Judicial Service Commission filed a notice to abide by whatever decision the court will make.
No, the notice to oppose is just the notice that gives the president's intention to say, I'm going to oppose the application. Then after he files his notice to oppose, he then comes with a filing sheet with his answering affidavit, which would be the extensive explanation, and it will answer to each and every allegation contained in the founding affidavit of the former president, where he says, this is the background, he sketches the background, so then he will answer to that. So the notice to oppose and the answering affidavit should not be seen as one document. It's two separate documents. Notice to oppose one side, then he has another 20 days to actually file his answering affidavit, or 15 days, whichever the days is indicated in the initial application that is given based on which court you operate from. So there will be opportunities. So these two documents should not be confused. Notice to oppose, he's given it, then he still has another 15 or 20 days, depending on the situation, to file his answering affidavit. And once he has filed that, the former president has then another, I think, 15 days to file his replying papers pertaining to the current President Ramaphosa's answering affidavit. So that it's just legal.
Okay.
That's what it's in the procedural frame. So there's just procedural time frames that we normally have to abide by as lawyers.
Got you. You mentioned that the judiciary should be seen as one. Overall, what does this look like, or what do the cosmetics look like of this case and this challenge between the former president and the current president?
No, I think it's maybe still, one can put it in the frame of political infighting, maybe, to say that he's going after, because Judge Raymond Zondo has been appointed. How much is it going to cost the taxpayer to actually litigate on this again? And I mean, Judge Raymond Zondo, if we look at it, 2023 is past, is another year, 2024, and then we're going to have a new Chief Justice. Then a different story. So why would we now go through this whole rigmarole of already fighting, where we could have used the resources in a very a more efficient way to actually, maybe for education, healthcare, policing. So I think it's like it's not good for the country, and also for the judiciary. It's drawing the judiciary, the JSC, into this political arena where they should not be seen to be involved in. Although the JSC has now said they will abide by the court's decision, by the mere fact that they are being mentioned, then people will now look at, okay, where's your deliberations? We need your notes, because we don't know if they're going to ask for discovery of the notes so that they can see what the deliberations was about. Obviously, using the right platforms like PAYA and these types of piece of legislation to get access, because these private and confidential matters that has been discussed at this meeting. So it becomes difficult.
Is it not equally important, Elton? You rightfully mentioned that monies could probably go to much worthier causes. Is it not also equally important that situations like these are checked? It doesn't matter who does it, right? But so that you establish the independence of the judiciary.
No, indeed so. But obviously how our constitution is written, at this point in time, the president has the prerogative to appoint our Chapter 9 institutions. So there will be some sort of that notion, or maybe that idea that the president appoints people that's aligned to him. That notion will always be in people's minds. But that's how our constitution, then if we as South Africans are not happy with it, then we need to go and say, but listen here, then we need to give our political parties the mandate to say, listen here, go to parliament and change this process. Because as it stands, the constitution is the supreme court of law of the land, and that's how it's written. The president can. Then to say to, okay, remove that power rather from the president and vest it somewhere else, maybe in there. And obviously if the president makes an appointment, he has to consult his cabinet, so he needs to have the overwhelming support of, but then we can also say, but the president appoints his cabinet. So if a cabinet minister goes against him, then he can remove them. So all that powers, but it's how our constitution is written, and there's nothing we can do about it at this point in time. Instead of just going to the legislature, change our constitution so that it can have that checks and balances that would satisfy people, to say that they don't see that sort of half that power, use of power over a person. If I appoint you in a position, then you're going to do what I say you must do, then we can try and address that issue.
Elton, thank you very much for your time this afternoon. Elton Hart is a legal analyst.